you who don't know me, my name is May McGarver. I'm Director of Atticus Business Accountants, and the inspiration for this video came about because a client recently rang me asking whether a worker they're considering bringing on into their business had to be an employee or whether they could put them on as a contractor. The blunt truth of it is it's not always a choice. There's some very strict rules that cover whether a worker should be correctly classified as an employee or a contractor. And these rules have received a lot of attention both from the ATO and the Fair Work Commission of late. So it's very important that when you are considering bringing someone on that you double check your obligations because the penalties that can apply to employers who get this wrong can be pretty severe. So I'm going to cover for you, because we get asked a lot, is what factors do the ATO look at in determining whether a worker must be an employee or whether they are eligible to remain as a contractor. The place I start from an employee point of view is three things. Generally, an employee is told what work is to be done, how the work is to be done, and when the work is to be done. If you have these three factors, you're very likely to have an employee relationship. Employees generally don't provide tools of their own, they can't delegate the work to someone else, and they're generally paid on an hourly rate. If we contrast that to a contractor relationship, a contractor runs their own business independently from yours, and even factors like whether that contractor wears your uniform when they're working on site for you are looked at by the ATO. They control the way the work is done, how it's to be done, and within reason, when it's to be done. They would generally quote the work and be paid to achieve a result, either the finished product or a stage. They would normally provide their own tools. They are eligible to delegate the work, say, to someone else in their business, like another trade person. And finally, a big one is who carries the risk. A contractor would have their own insurance and would be therefore liable to rectify at their own cost any defects or corrections that need to be made to the work. A big misnomer that I want to cancel today out is a lot of employers will say to me from time to time, but the contractor provides me with an invoice and an ABN, so they're a contractor. The ATO don't consider that to be a definitive factor. They go back to all the rules that I just spoke about. And the important thing is that there's no one section of those rules that are definitive. They look at the rules as a whole and look at how the work's done, how it's paid, and who's carrying the risks, and all of those factors, and weigh those factors up on a balance of probabilities. So it's really important that you're looking at the entire situation and considering the whole relationship and where it falls on which side of the ledger, so to speak. To help you make a decision, the ATO have produced a really great employee contractor decision-making tool, and you can find that for free on their website. I'll include a link to help you in the comments to this video below. And I find that excellent for quite simple situations where you can just run your scenario through that tool and it spits out a result. And I often encourage my clients to keep that on file in case the ATO ever review the relationship. You've got some evidence that you've taken steps to make sure you correctly classify this. However, within those 6 or 8 factors, there's a lot of grey areas, and like I said, there's no one defining factor that would sort of seal the deal, so to speak. So if you're ever unsure, it's really important that you get some advice and at very least run the relationship through the decision-making tool on the ATO. We're here to always help businesses make sure that they're not only complying with their obligations, but they're minimising their costs and particularly risk of penalties, because this is a big area that the ATO are looking at. Another misnomer that I want to clear up as well is there have been instances where contractors have pressured employers to put them on as a contractor rather than as an employee. The ATO don't take lightly to this situation, and in fact, if you were found as an employer to have incorrectly classified that worker as a contractor, despite the fact that they pressured you, the ATO would still apply the penalties to the employer. So There's a big obligation on employers to make sure they get this right, and the penalties can be fairly severe in terms of the unpaid tax that you should have withheld, superannuation, as well as penalties on top of those obligations. So important to always look at this. It is a big area the ATO are focusing on, and if you ever need any advice to help you stay on the right course and on the right side of the ATO, let us know. We're only too happy to help. Thank you.